When can you sell inherited property in Virginia? Well, when your name is on the title. There are a couple of ways to acquire title after someone has died in Virginia. You can either inherit by and through joint tenancy, which is the most common thing. You could inherit as transfer on death beneficiary. You could inherit under the terms of a will. You could inherit under the laws of intestacy, or you could inherit under a trust. And so what you need to do is you need to get title put in your name after that person has died, so that when you go to the closing table, you can convey the title to the property with all of the English covenants of title, basically clear title. Let's go back to those situations. If you inherit through joint tenancy, then all you need is a death certificate and you can go straight to selling the property. If you inherited through transfer on death deed, you need a deed of confirmation that puts the death certificate on file and confirms that you are now the title holder of the property. If you inherit through a will, that will has to be admitted to probate. If you inherited under intestacy, someone died and you were the child of that person, for instance, then you need to have a list of heirs filed. That will entail probate initiation proceedings in some cases. And finally, if you inherited under a trust, then the trustee can convey title to you as soon as they're comfortable doing so and as soon as you survive the required amount of time under the terms of the trust. Typically, that's going to be longer than under intestacy survival type provisions. In most trusts, you'll see a requirement that the beneficiary must survive the decedent by the trustor by 30 days. In the case of the Gene Hackman estate, there was a 90-day requirement. So that's up to the document to say. If you do sell inherited property under intestacy, you should be aware of this one further thing, which is that title is going to be subject to an extra hazardous risk premium title policy when you get to the closing table if you sell that property within 1 year of the date of death of the decedent. Now, the 1 year mark is magic in Virginia because you have 1 year to come forward and make your claim as a beneficiary of a person's estate that died as a resident of Virginia. So if you are going to convey the title to someone else within that 1 year statutory deadline, then the title underwriter is going to insist on a rider to your title policy that is called an extra hazardous risk premium. So you're paying more money because it's a more risky conveyance in the title company's eyes. So if you need any help with selling inherited property, please reach out to us, especially if you are an out-of-state beneficiary of a Virginia resident's estate. We can help make that situation a lot easier for you through limited powers of attorney or even through the qualification of a Virginia administrator. So reach out to us at Speedwell Law if you need any help with any of that. Thanks.